Alrighty, folks, this is George. I am a founder of Solo, and this is the Debt Hotline. We are here with John Skiba. How's it going, John?
It's doing great today. Glad to be here, George.
Great. John Skiba is an experienced bankruptcy and consumer rights attorney and owner of Arizona Consumer Law Group. He has helped more than 10,000 families struggling with overwhelming debt issues. He runs the Consumer Warrior YouTube channel with more than 70,000 subscribers, and he helps educate consumers on how to settle debt, how to resolve their debt issues, how to get people paid back and get on the right road. So thanks again for coming on to the show. Folks, this is a live hotline, so if you have a question, you can just call in at 801-613-8181 and get your questions answered. You can talk with John and myself. So let's go ahead and call the hotline 801-613-8181. We also have people who've written in questions ahead of time that we'll try to get to. We got somebody on the chat. Hi, Jeff. How's it going? Jeff saying hi from the chat. So the first question here, we have a lot of people who, consumers who are working with Cavalry SPV, and they want to settle with Cavalry. They want to pay them back debt that they might owe them. John, what's the best way to go about doing that? How can people settle and get things fully resolved with Cavalry?
Yeah, with Cavalry, they will often. I mean, they purchase debt, so they buy charged off debts. So a lot of times, I see the first reluctance that people have is they don't know who Cavalry is. They're thinking, hey, I didn't borrow money from Cavalry. They didn't loan me money. Who is this company? Some people think it may be a scam, but they're a large debt buying entity. They buy old charged off debts and then they collect on it. And so I think a good question, first of all, if you have those concerns, is you can ask them to verify the debt to get an understanding of who the original creditor was. Often in the correspondence that they may send you, they usually will put who the original creditor is, but you can get additional information to make sure that you're dealing with who you think you're dealing with on that, and that way that can kind of be the first step to getting it resolved. They do file a lot of lawsuits. The thing that I preach nonstop is I think it's a good idea to file an answer to the lawsuit, to give yourself a little bit of time to start that negotiation process to determine, is there some middle ground that you can get with Cavalry as you're trying to come up with an overall resolution to it. It makes it so there's not the pressure of having to, worry about a default judgment or anything like that. But the first thing overall is always communication. People tend to avoid that because they're worried about if it's going to be contentious or it's going to be awkward or whatever, or maybe they're in a situation where they don't feel like they have much to offer. I always say communicating and reaching out and trying to resolve it is going to be the first step of really, getting you where you want to be.
Yeah, for sure. Over communicate, right, is really a great idea. Yeah, so a lot of questions, right? So one of the main questions on people's minds when they get contacted by Cavalry is, right, who is Cavalry, as you mentioned. Yeah, folks, Cavalry is totally a legit company. They will have the right to collect on the debt because the debt was assigned to them from the creditor, right? So let's say you have like a debt with Discover or something like that. Like a debt with Chase Bank, and then Chase doesn't want to try to collect on the debt, and for whatever reason, they can then sell that debt to somebody like Cavalry, who is a debt buyer, and then Cavalry can contact you about the debt, right? They can try to collect, they can sue you without notice. They don't have to like tell you they're going to collect on the debt ahead of time. They can just sue you for the debt, and then things can move forward, right? And so definitely the best way to get this thing resolved is to find a way to pay back the money that you owe, right? So to settle the lawsuit, oftentimes you're going to be able to get some kind of a deal for resolution. Like if you have a lot of the money available right now, you can use that to pay off the debt. Oftentimes collectors will be willing to get you onto a payment plan of some sort where you're like paying money over time. But there's lots of resolutions, and you can connect with them on Solo Settle. So you can use our platform Solo Settle to connect with the collector and find resolution options that work for your specific situation. Okay, so that's a great path to go down. All right, we have a question recorded ahead of time from Jenna in Texas. So let me go ahead and play that here.
Is Jenya, and hi, my name is Jenya, and I am from Texas. Cavalry suing me for $2,700. 3 years ago, I lost my job, so I had to let go all my credit cards. I'm still recovering. So I sent an answer generated by SoloSuit, received reply mail from the lawyers, Jenkins and Young, with affidavit of claim, bill of sale, affidavit of sale, and affirmation of sale account, also 12 statements. When I went to court, judge said that she had all of the proof from lawyers and I have to pay. So she was fair and scheduled another hearing, giving me time to negotiate. And I tried to negotiate, and they lowered the amount to $1,400, but wanted 2 payments only. I did send them all my bills and pay stub explaining that I cannot make those payments due to making $16.75, so $590 a week, and it's barely covering my essential needs like rent, car payment, electric, insurance, phone. So I don't have any savings, no money, bad credit, no family to borrow the money from, and Cavalry sticking with $1,400 with 2 payments option. So my next hearing is next week. What can I do? What trouble will I get to, because I cannot make no payments? What are my options? I just don't have any money to pay all of this, otherwise I would. Thank you so much.
Alrighty, so that is Jenya in Texas. Thanks for calling in. Right, sounds like you're in a tight spot. You're in a lawsuit with Cavalry. You're trying to pay them back. You don't have money to pay them back. John, what can Jenna do here?
Yeah, no, that is a tight spot, especially because the judgment's been entered. The whole reason why plaintiffs, creditors file lawsuits is to get judgments, because the judgment turns an unsecured debt where, truthfully, the biggest hammer that I would say that a collector or a creditor has is the damage to your credit score. Once they have a judgment, they can do things like wage garnishment. Although in Texas, I don't believe they have wage garnishment. You might know that better than me, George, but which always surprises me. I don't know why.
Texas doesn't have wage garnishment, but they have, I forget what it's called. They have something very similar that really works pretty much the same way.
Okay. So, but with the judgment, there's garnishment, wages, bank accounts. They can record it. It can act as a lien against any real estate that you own. I guess to me, the one silver lining here, it was $2,700, $2,500. That's a manageable amount. You know, it's something where eventually you may be able to come up with something, or sometimes I think sharing the hardship information, like she was saying, can result, and I'm talking more globally to anybody who's listening to this, sharing some of that information if a judgment's been entered as to why you're not paying, or something that's maybe more realistic. I've seen collectors and debt buyers like Cavalry even accept minimal payments, $30 a month or something, you know, until more substantial payments can be made. It's something where, I mean, if it absolutely you cannot pay it and it's causing a situation where you can't get it settled, you know, both sides are kind of dug in their positions, people will look to bankruptcy. I wouldn't recommend filing bankruptcy over if this was the only debt issue, but if there's other, you know, if this is kind of one symptom of a much larger issue, a bankruptcy will work as well, and it eliminates judgments and the underlying debt. But at the end of the day, if it's something you can't do it, I mean, you can't do it, and you may need to just wait and be patient. And most states do have some type of exemptions that will protect some money in your bank account, protect like your vehicle. while you're kind of getting on your feet so that you can propose something that might be more agreeable to the creditor.
Yeah. Yeah, it sounds about right. So in this case, you said Jenna had already lost the case, right?
I thought that's what she'd said, that a judgment had already been entered. Yeah.
Right. Yeah. So generally at this time, right, you're just trying to either get onto settlement plan or have your wages garnished, right? And it sounds like, yeah, I mean, a settlement plan would be nice, right? Because it'll be a little bit less than like the garnishment, probably monthly. But you are in a tight spot here, Jenna. I think, really, it's hard to say. I'm sure it won't be easy. You're really looking at a situation where you need to find a way to increase your income to get out of the situation, right? Can you get a second job? Can you get a third job? Can you work weekends? What can you do to increase your income so you can get out of this this situation, right? And bankruptcy is always an option for you as well.
Yeah.
Something else to consider. All right, we have another question here from Dana. And here we go.
Hi guys, my total debt owed is $9,200. A credit union in Oklahoma has been the one contacting me. Yes, I've been sued, and my court date is October 28th of this year. I don't really have any other debt and collections, and the reason I fell behind, my husband and I started and took over a small business, and then COVID hit, and we could not make any income or any payments at that point. My question for you all, the credit union in Oklahoma is the one suing me and want to do a garnishment and all that. However, I keep receiving emails from Chase because the credit card's actually like through Chase. And the last email I've received from them, they only want me to pay 15% of the total balance owed, which is around $1,400. They say that if I pay that, then all collection actions will be halted. I want to know if I pay that $1,400, if that means that my settlement can be dismissed.
All right, so if she pays that $1,400, can her settlement be dismissed is what she's asking. What do you understand from that, John?
And I guess I was a little confused as if that's different from the $9,200 with the credit union. But so I should say this, kind of a general principle overall is where things can kind of go south is when there's a misunderstanding or that things are not clear. And so I recommend before you pay anything, you need to have something in writing. And that writing can be an email, it can be a fax, if people still send faxes. I don't know, but just something in writing where it's really in black and white written out. Okay, what is this meaning? If you pay this $1,400, are we done? Is everything settled and resolved? Is it something where the $1,400 takes it out of active collections, but then they're going to come back and try to pursue the rest in payments or something like that? So I always tell people before you pay anything, even if you're on the phone with them, and they're saying, hey, we'll do X, Y, and Z to get this settled and it's a good deal, get something. They'll legitimate collectors, banks, creditors, they'll send you something to be able to make sure that, because it protects them as well, to make sure that you're all on the same page before you do it. And like I said, if they're legitimate, then it's something where they won't even give you pushback on that. They'll want to put it in writing.
Right. And yeah, Dana, definitely want to get things in writing. It's best for everybody, including the collector. And if you settle, usually if you're in a lawsuit that's pending, usually what will need to happen is you'll need to enter into a stipulated judgment agreement, which like the settlement will stipulate that if you mess up the payments, if you lose the payments, if you miss payments, then the collector can basically activate the default judgment against you and then move forward with garnishing your wages. So it's a little bit of a risk for you, but it's certainly it's kind of necessary at this point in time to get that settlement. All right, folks, if you have a question, we have lots of people watching live right now. If you have a question, you can call 801-613-8181 and you can chat with us and we can see what we can do to help. We have a question here from Joe Fay in California. I'm being sued by Cavalry SPV LLC. The attorneys are Nelson and Kennard for $5,546.45. That's just pointing out here, right, for Joe Fay, right? Remember, Cavalry is a legitimate debt buyer. Nelson and Kennard is a very active law firm as well. They do a great job in the space. There are no other debt in collections. I could not make payments due to not being employed. I already filed an answer courtesy of Solo. The court date is approaching. What is the next step for this lawsuit? Hopefully, without going too far to court, the court's 20 miles away. Definitely a real situation. Yep, oftentimes the court is a long ways, and in California, 20 miles can take you about 5 hours. Also, what age is appropriate to be considered exempt from collections as a senior? As of now, my qualifying for exemption under state assistance, I want to avoid a default judgment. Joe Fay, the good news is that you already did avoid a default judgment by getting an answer filed properly using Solo. And that can give you, that's a good starting place to get the case settled, right? So from there, it's really just a step towards getting the case settled. John, what else can you provide here to Joe Fay?
Yeah, the exemption you're talking about, I mean, certain funds are exempt, like Social Security, VA disability, those types of funds in every state cannot be touched by a creditor. You mentioned like an exemption as far as a certain age. I'm not aware of any exemption based on age. I do know that, your current situation, jobs, age, assets, other debts, those things can all come into play in trying to negotiate a settlement. I can tell you when I here in Arizona in my law practice, when I'm trying to negotiate a debt, I view it, my job is really to help the debt collector's attorney or the debt collection representative to be able to really sell this to whoever the decision maker is. Of saying, look, I've got this client who is on Social Security, 73 years old, not working, doesn't have real estate. This is as good as it's going to get, and this is the settlement we can offer and that could realistically be afforded. So I think those are the kinds of things that you need to think of when you're approaching it. The fact that you filed the answer is good. Sounds like you've got a trial date coming up. You can review the documents. They're going to have to provide you with their exhibits and all that. You can review that to make sure that things are consistent, to make sure that your account was actually transferred between the parties. It is difficult to represent yourself in trial. I can just tell you that you're going to be going against lawyers who this is what they do all day for a job, and so they're trained lawyers, and it can be difficult. It's not impossible. I talk to people every day who've represented themselves and done a good job in defending their situation in court. I always say, though, when it comes to trial, the reason why trial is always risky, even as a lawyer, it's risky because it's all or nothing. You're either going to owe zero or you're going to owe the full balance plus attorney fees, plus interest, plus cost. And so by trying to settle a debt, you retain some of the control as far as the overall outcome. Yeah, you're going to have to pay something. They're not going to settle for zero, but you do retain some control over that. And that's where sometimes having a mediator, like a solo settle, or sometimes courts will provide mediators to come in and have an independent third party kind of help to facilitate that. That can be a big benefit because you can retain some control of the final outcome of what it is you're trying to do there.
Yeah, John, I think you make an important point, right? It is winner takes all in the U.S. court system, right? It's a risk, both sides. one side wins everything, one side loses everything, just like a U.S. election. It's winner takes all. So that's why there's big incentive to settle beforehand, right? And settlement's usually like a meeting in the middle. It's a compromise of some sort, rather than
George, if I could real quick, just because I can tell you that's one thing when I talk to people all day in my law practice, that's a big misunderstanding a lot of people have is they think if they go to court, the judge may negotiate or just say, okay, no, you're going to owe half or find some middle ground. That's not going to happen. The judge is the umpire. They're just to say liable or not liable for the full balance or zero. So I think it's important for people to understand that if they've been sued by Cavalry or anybody else, the benefits to settlement are, that you may be able to come up with something that's realistic. Trial's not the place. That's where it's all or nothing.
Yeah. I was talking with a friend, right? I get people kind of asking me like general legal questions from time to time. I had a friend who got their 5th speeding ticket in, I think, less than 5 years. And they went to like so in Utah, they went to the pre-trial like settlement kind of deal that I think is common in most states. That's what Utah does. Like, they kind of request you come in, meet with the prosecuting attorney, and the prosecuting attorney will tell you, you're gonna lose if you go to court. You should just take this deal. And she pled not guilty and said, let's go to court. And she was doing that mostly because I think she was banking on the police officer like not showing up, right? I think kind of that myth that doesn't exist in Utah, maybe it exists in some other states, like the chance that the officer is not going to show up. And yeah, I just had to point out to her that, hey, if you plead not guilty, you show up in court, and the person like confided in me that they were speeding. There's no doubt. And you go to court, like the judge is going to rule entirely against you if in fact you were speeding, right? That's like all there is to it. Were you speeding or not? Speeding is a strict liability crime. Were you speeding or not? If you were speeding, the judge will rule entirely against you. And then it's just a question of how bad the sentencing is, how bad the charge is.
Yeah.
So thankfully the person settled out, right? They called the attorney, the state attorney, and kind of pled for a settlement pre-court, and ended up paying quite a bit of money, but it certainly wasn't as bad as going before the judge, and probably in this situation having their license suspended.
Yeah.
So even in that situation, right, settling before going to court is best because the judge will grant some kind of a winner takes all ruling.
Yeah.
Yeah. You ever deal with speeding tickets? You ever do that kind of thing in Arizona?
I haven't. I was a prosecutor for the Maricopa County Attorney's Office for a very brief time early on in my career.
Mm-hmm.
We dealt with the criminal speeding, the DUIs, and also,
Mm-hmm.
the outrageous, the 100-mile-an-hour plus speeders. But I haven't dealt with it since then.
Right. You dealt with the exciting cases.
Well, I don't know if they're too exciting, but I dealt with them. So
nice.
I did juvenile crime for a while. So I was dealing with teenagers, which that's a whole other story.
Yeah, that'd be hard.
Yeah.
That would be hard. All right, folks, if you have a question, call in to 801-613-8181. You'll talk with our wonderful assistant on the show, Hannah, who will kind of let you know how this process works. We have a question here from Mina in California. I was sued, and after the collector failed to appear on 2 separate court dates, the judge dismissed the case. How do I work to remove this from my credit report, or will they stop reporting it to the bureaus on their own?
Well, a lot of it will depend on how it was dismissed. If the case was dismissed, so often what happens if the other side doesn't show up, the courts, at least in my experience here in Arizona, they'll often dismiss without prejudice, meaning the case can be refiled. If that's the case, if it was dismissed without prejudice, my guess is it'll still be on your credit report. It's kind of two different things between, the court process and the credit reporting process. And so you ought to look at the judgment or the dismissal order. If it says it was dismissed without prejudice, or if it doesn't say with or without prejudice, likely the assumption is it's without prejudice. It could then be refiled, assuming that it's within the statute of limitations, the lawsuit could. And so it's likely still on your credit report. If the court dismissed it with prejudice, which is what I always push for, if the other side doesn't show up, sometimes I'll have the judge say, okay, we'll dismiss or we'll reschedule. And I say, hey, respectfully, judge, if I didn't show up, judgment would have been entered 5 minutes ago. Most judges will agree with that. And they'll say, okay, we'll dismiss it with prejudice. If it's dismissed with prejudice, that can be treated as an adjudication on the merits, meaning that it's done. It can never be refiled again. And I think you do have an argument there to have it removed from your credit. My experience is that the creditor is not going to do that on their own, that you'd have to file a dispute through the credit reporting agencies, through Experian, TransUnion, Equifax, those people, and provide a copy of that judgment. And then that will usually get the judgment eliminated completely. But so you need to go back and look at your judgment and see exactly what the court did. If it was dismissed without prejudice, you may not be able to get that removed just quite yet.
Fascinating. Yeah, that's a interesting one. I didn't realize that if it's dismissed with prejudice, that can be considered an adjudication on the merits of the case. So you're saying that it's if it's dismissed with prejudice, that can be considered essentially like as if the case happened.
Yeah, so I've had cases where like we show up to trial, and for whatever reason the plaintiff's attorney doesn't show. I will ask that it be dismissed with prejudice, and especially if it's in a trial type setting. That was it. That was their time to prove the case. The court will dismiss the case. I always ask for language in there saying that the plaintiff shall take nothing under their complaint, and then that is an adjudication on the merits. And so at that point, they can only not refile, but the debt is not owed. The court has said that there's nothing owed, that nothing can be taken on it, and it cannot be refiled. And like I say, my experience is the creditor doesn't just reach out and contact all the credit bureaus and let them know. But I have had success with filing a judgment like that, saying judgment was entered in my favor. It's got to be removed. Same thing if they do show up and you win on the merits, that can be submitted to the credit bureaus to have it removed completely.
The collector can still collect on the debt outside of court, even after dismissal of prejudice in this situation, right?
I don't believe they can if it's been dismissed with prejudice. Because it's hard to think of a time when dismissed with prejudice would not be considered a true adjudication of the case. Just a simple dismissal. And where I run into this a lot in practice is where a creditor will say, we're just going to voluntarily dismiss this case, walk away from it. There's some problem that they have. They can then continue to voluntarily do that. But if it's dismissed with prejudice, my opinion, John Skiba opinion here is that I think that's an adjudication on the merits, and they shouldn't be able to collect on it. But I'm sure there's debt collection attorneys that disagree with me.
If it is dismissed without prejudice, they can certainly try to collect outside of court.
Yes. Yeah. If it gets dismissed, and like I say, a lot of these cases are, if they don't serve you quick enough after they get it filed and it's dismissed without prejudice, then yeah, absolutely, they can continue to collect on it.
Well, so how does the dismissal with prejudice differ from a court order saying that you won the case?
Well, I mean, if you go to trial and the judge says, okay, I've looked at the evidence of both sides, and consumer, defendant, you win. The plaintiff did not prove their case, and so they're going to take nothing on it. That's a full adjudication on it that's been decided. You don't owe anything on that debt, and it's done. They can't do any type of collection on it going forward. But if the court just dismisses it because of a procedural thing, because in most jurisdictions they file the lawsuit and they have a certain number of days to serve you. I see that frequently here in Arizona. They have 90 days to serve them, and they don't. So the court dismisses the case. They're going to let them refile that if it's within the statute of limitations. and then you're going to get an order. The order will just say it was dismissed without prejudice, and then they can, if they want to, they can continue to pursue it. So a lot of it's going to be in the language in the order, the judgment, the minute entry, whatever the court issues, that is going to determine whether they're going to be able to still collect on it.
Interesting. All right, folks. We posted a link into the chat. If you want to support John Skiba and you want to settle your debt, you can use this link. It'll take you over to our website where you can make an offer, find out resolution options for you and the collector. So go ahead and check that out and see if you can see something that will work for you there. Looks like we have somebody who is calling in live that we can plug in here momentarily. In the meantime, let's see a quick question here. We have, let's see. We have a question from Joe. I'm being sued by a debt collector, and my first hearing, the judge basically sided with the collector, and they were missing some documents. Then the judge said they had to file it quickly. A year later, the judge was going to issue a motion for dismissal because of lack of prosecution. Okay, I'm not sure if that's really a question, but yeah, it sounds like you went to court, right, for being sued for a debt that you agree that you owe somewhat. Definitely best option for you is just to try to settle and get that thing paid back somehow. Okay, let's jump into this question here from Hannah. Is Tamara ready to go here? Just hang out for 1 second. Okay, let's go ahead and plug in Tamara.
Hi there, can you hear me?
Yep, this is George. How's it going?
Hi, George. I'm doing well, thank you. So I have 2 questions. Hopefully they'll be fairly quick and give you an opportunity to answer. I have one of the prepaid legal plans through my employer, and I was served with a lawsuit from, I can't even remember the company name, but it's basically Care Credit, whoever their parent company is. The amount was $806. Unfortunately, I had a brain aneurysm and was out of work, and a lot of things got crazy for me for about a year and a half. I reached out to one of the attorneys in my plan. They took the case, contacted the plaintiff's attorney, and like a month went by and he said, "Hey, I'm still trying to negotiate for you. Don't worry about it." 2 months went by. "Hey, I'm trying to negotiate." I'm like, "Well, it's been beyond 30 days. Shouldn't I have filed an answer?" And he's like, "No, you don't need to file an answer. I'm still trying to negotiate for you." And then 3 months have now gone by, and I contacted the attorney's office and they say, "Oh, he no longer works here." So what should I be doing right now? Because I can't get the plaintiff's attorney to respond at all. I have not been served a court date, and I don't have a garnishment. It just looks like they dropped off the face of the earth.
Okay. Yeah, thanks for filling us in here, Tamara. So it sounds like, just getting some basics here. It sounds like you're being sued for, did you say 800 or 8,000?
800.
Okay. So $800. And did you say you have been sued officially for it, or you haven't?
Yes, I was served with a lawsuit.
Okay. What was the service like? Was that pretty rough, pretty straightforward?
No, actually, and I didn't realize this, but when I was talking to the attorney, I said, basically the person came to the door and I wasn't here at the time. And so they called me and I called them back and I said, well, just come on Tuesday at 3 o'clock and I'll be here. And so I signed the papers and that was it.
Nice. Well, way to not dodge service. I mean, that's the best. That's the best move. Definitely, just best to get served and get that over with. Uh, so it's with Care Credit. What kind of stuff does Care Credit do? Is that a credit card or is that personal loans? What do they
It
do?
is a credit card, but it's just for medical purposes.
Right.
And
Yes.
so, yeah,
Right. Right.
I unfortunately had like 12 accounts going to collections. Some of the companies I was able to negotiate with once I got myself together. But a couple of them I was not able to reach in time. And I currently have 2 lawsuits pending. I had a third one that I made a payment arrangement on, but that one where I had the attorney working on it for me, like I'm just in limbo, and I know I was supposed to respond in 30 days, but and I have emails to say that no, you shouldn't respond. I've got it taken care of, but I haven't paid anybody and no one has contacted me again.
Oh, okay. So you had 12 accounts going to collections. This one you're in the hospital for a brain aneurysm, and then
Correct.
someone presented you with a Care Credit card, like while you're in the hospital, in order to pay for the medical bills.
No, I had that account before the aneurysm happened, and I had
Hmm.
been paying on it for years and using it and paying it. So there was no issue with it until I couldn't pay because of my hospitalization and my illness and, being out of work for a while. So just everything piled on at
Yeah.
one
Yeah.
time.
Yeah. Sorry to hear about the situation, Tamara. It must be real tough going through all this.
I'm doing much better now, though, thank God. So
Good. What do you do for work?
I am a IT project manager.
Oh, sweet. That's great. Happy to hear. Sounds like a solid position.
Yes.
Sweet. Uh, okay. So, uh, I mean, so generally speaking, if people come to us and they haven't filed an answer, right, it's usually good practice it's best practice to file an answer. We consider that to be like the first step of engagement with the collector and usually a step towards settling. Uh, if the deadline has passed, we see very good success with including a motion to set aside judgment, sometimes called a motion to vacate judgment. There's probably a default judgment entered against you on this case, probably, but you'd want to check the docket and see if there has been one. If not, you can file an answer. John, biggest question in my mind is, might not be worth it, but is there a malpractice claim against the attorney? Probably don't need to worry about it because there's no damages at this point necessarily. But certainly seems kind of questionable what this attorney did. There's probably something more that we're missing. But John, what do you think?
Yeah, I mean if the lawyer just dropped the ball, I mean that's problematic for sure. Because I mean you hired them to do this particular task, and they didn't do it, and now they've just disappeared, kind of thing. So I mean the state bars often deal with these kind of issues. Sometimes they resolve them, and sometimes they people sometimes are unsatisfied by the resolution with the bar. Because the danger with this and the issue is if an answer isn't filed, even if you were to go to the court and say, I hired this attorney, they didn't do it. Sometimes the courts will say, well, that's, you're kind of stuck. And then you may have to do something like George was saying, like file a motion to set aside the default judgment. And I'm sorry, what state were you in? Did you say?
Georgia.
Georgia. Okay. I don't know how the statutes work there. I know in some states, a default is not really fully entered until sometimes the creditor or the plaintiff has to take action. It's that way in Arizona. So I would definitely contact the court. That's the first thing I would do and say, hey, has a judgment been entered? Let's find out what the status is here. If a judgment has not, I would get an answer on file, use solo or just get something there so that you could avoid having that default entered. And again, I mean, it's one of these things too, where you're dealing, it's under $1,000. I'm always surprised creditors sue for this amount because there's a lot of work that goes into a lawsuit just to, but you don't want to get the default because they could try to add interest and attorney's fees and all that. But if it's under $1,000, it's usually something that can be managed with a settlement, whether it's even a 50% settlement, and try to get the thing resolved. I also see medical collections tend to be a little more open to settlement sometimes than, like an American Express card or something like that. But first thing for sure, I would call the court first thing tomorrow and say, I got to find out what the status is here because my attorney's kind of abandoned me here.
Right. Yeah. Okay. That's definitely helpful because I just didn't know what to do and what am I waiting for? What am I expecting? And as I told the attorney when I called him, I just want to pay this. I didn't mean it to get here. And, if you can settle it for less than the 800, fantastic. But if you can't, I'll just pay the 800. And so it just went left from there. I don't know. It makes no sense to me.
Right.
But I will do what you recommend.
Yeah. Yep. That sounds like the right move. And Hannah can help you find the online docket. We have a great resource on Solo, a list of online case data for all of the states, including Georgia. We can point you in the right direction there. See if a judgment has been filed. Sounds like probably it hasn't. What was the prepaid legal service that you're using?
MetLife.
MetLife?
Mm-hmm.
Okay. And then, I mean, if you wanted to investigate further, not saying that you necessarily should, probably not much would come of it, but you can always, search your attorney in your state bar directory. I think every state bar association maintains a directory of attorneys, so you can find the Georgia State Bar. You can search that attorney name, find out his license, and make sure that it's like active.
Okay.
And if
I will definitely do that. If I may ask you another question, it's in reference to one of the other lawsuits where it was for about $10,000, and I did go through another attorney, and she was able to negotiate on my behalf, like a $260 a month payment. But I had to sign a summary judgment or consent to summary judgment. And I really don't understand what that is, except for saying that I recognize that I owe the debt and I'm paying it. But what does that really do? Do I have like a judgment against me on my credit report? Because I haven't seen one. Is that what happens with those consent to judgment?
John, do you want to jump in on that one?
Sure. Yeah. So that's pretty standard, particularly if there's going to be a payment plan over time with a settlement in a lawsuit, is that the parties will enter into a consent judgment or a stipulated judgment where essentially, what they're saying is, say if I get sued for $20,000 and I'm agreeing to settle for 10, the stipulated judgment will have terms in it. It will say, look, we sued John for $20,000. he's agreeing is to pay 10. He's going to pay $200 a month, no interest for so many months. But if John doesn't pay the settlement, then he defaults on this, and we get a judgment for the full balance, for the full $20,000. So it's a way for you to get a reduced settlement, usually on a payment plan over time. And two, it gives the creditor some security. If you fall through on that payment plan, they get their full judgment that's entered against you. And so it can be a powerful tool. I think from even a consumer's perspective, when I negotiate these things, I mean, I've negotiated stipulated judgments for 7 years, on lower payments, because that's what works for my client, and we get a reduced balance. And as long as you keep making the payments on it, it can be a pretty good thing. If you don't, all of a sudden they don't have to go back and sue you again. They've got their judgment, and it's usually for a higher amount. It also doesn't surprise me that it's not showing up on your credit report. They changed the rules back in 2017, and judgments do not show up in the public record sections anymore, except in really rare circumstances. So it's possible for there to be a judgment on the court docket, but not be a judgment on your credit report. The account may be there, but not the actual judgment. So that's likely what you signed from what you're saying, was some type of stipulated judgment.
Yes, thank you so much. That gives me a great sigh of relief for both of those scenarios. I appreciate you all so much. Love all the streams that you all do, and keep doing the great work. I appreciate it.
Thank you, Tamara. Take care. So folks, just highlighting our solo steps. So we want everyone here to become millionaires. That's what we're dedicated to at Solo, helping people bounce back from broke to become millionaires. Step one is respond to your lawsuit. So if you're currently being sued, get that lawsuit wrapped up. Step two is settle your lawsuit. Step three is settle all of your other debts. Sounds like Tamara is well on her way there, right? So she had 12 accounts in collections. That's a lot of accounts, folks. She's getting all of those settled. Sounds like she's making income again. She's back on the right path. I think she can be an inspiration for all of us, really, of bouncing back here. Step four, save $1,000, put it into a stash that away. Make sure your legal foundation is all set. Do you have a will in place? Do you have an incorporation for your business that you're running on the side, etc. 5, automate investments into index funds. Great for building wealth. Ownership is key for wealth. 6, boost your credit score to 800. Definitely aim for 750. 750 is going to be attainable for everybody. Getting up to 800 will take some time, but everyone can get there. And then 7, become a millionaire. Takes some time. Once you're automating these investments, everybody listening to this can get there. All right, we have another caller who has called in. Going to plug in Ron now. Ron, how's it going? This is George.
Hey, George, I'm doing good. Can you hear me okay?
We can.
Okay. Thank you for taking my call. John, the question is, a year ago, April, we filed with a bankruptcy firm, Chapter 7. We paid the retainer, and we got the retainer, and basically the cease and desist letters were sent to the creditors. Since that time, I've been having difficulty getting anybody besides a clerk. I did finally get a hold of an attorney. I spoke with him in June, pre-trial video meeting. The attorney said that we had too much equity. We never should have been allowed to go through with the lawsuit in the Chapter 7 in the first place. Now creditors are calling me again. And I did have my first hearing last week. The judge rescheduled it till later on next month in order to try to negotiate a settlement with Capital One. The question is kind of twofold. Do I have any legal standing based on what has happened, what has transpired here, especially getting my money back, and any other legal grounds against the law firm that for this amount of time that we've been basically telling the people to call the law office and no response.
Okay, so you filed for bankruptcy, or you didn't, or you thought you did and they didn't, or explain, just clarify that a little bit for me.
Right. So we paid the retainer to a law group. In the meantime, we're sending in, all the monthly statements, etc. And then we sent the letters that they provided to the creditors. We retained the law group to file Chapter 7. It was never filed. So it was never filed. The bottom line is it was never filed. And we finally found out, over a year later that, hey, wait a minute, you can't file. The attorney that you originally talked to was wrong.
Okay,
Now
and you couldn't file because you had too much equity.
Yeah, the equity in the house. I don't know if it's because it went up or not, but too much equitability. So that's not an issue as far as that garnishment.
Okay. And so you're now you're dealing with a lawsuit because they're coming after you, and you're wondering how to deal with that, or you're wondering if you should go back to the bankruptcy.
Yeah.
Okay.
Exactly. I'm wondering how to fight them off if I can't qualify. Of course, I have against the law firm.
Yeah, it's a bad episode of the debt hotline for lawyers today. we're not making a good showing here because I mean the communication there was not good for sure, and it's something where if you didn't, if Chapter 7 wasn't a good idea, I mean I guess it's good it wasn't filed if there was too much equity in your home because they could sell your house in a Chapter 7 if the equity is too high. So I guess I mean with the lawsuit, I mean it sounds like you're doing what you need to do. It may be necessary to bring on a lawyer to help with that, but for sure, showing up, going to the hearings, going to the pretrial conferences, and then still trying to negotiate it. Now, the fact that this attorney did you wrong on the bankruptcy side is not going to really play, the courts, everything else. It's not going to play a role in there. Again, the courts are the umpires just saying liable or not liable. As far as recourse against the law firm, I mean, legal malpractice is not my practice area. I mean, it's literally there's attorneys. That's all they do is represent people who have had situations that were like this. A lot of people do go to their local state bar. Some state bars have recovery funds where when people lose money or they paid an attorney money and they don't have the ability to get it back, that they can help with stuff like that. At a minimum, they can bring the attorney and call them on the table a bit and try to get them to essentially make things right, or see if they have insurance. Most attorneys carry malpractice insurance. How much is the lawsuit that you're being sued for?
This one is like $2,700, but it's the first of other ones, right, that were involved in the lawsuit. So this is the first. I think it's $2,700.
Yeah.
What kind of debt are you dealing with altogether?
About $20,000.
And what's your equity position like?
Can you still hear me?
Yeah.
About $20,000. Can you hear me okay?
Great. Yeah, I can hear you on the, it's the 20K in debt. What's the equity position like on your house?
Equity's probably looking at right now about 80,000.
What state are you in?
Say that again.
What state are you in? Sorry about that.
What state?
Yeah.
Missouri.
Okay. Yeah, I mean, another option may be, and I don't know if you can hear me okay, but another option may be, you could go back and look at a Chapter 13 bankruptcy if the equity position is too high. In Chapter 13, you're not going to lose your house, but you may have to pay some of that debt back over time. So that may be something to take a look at. It might be good to get a second opinion of another bankruptcy attorney there. Find someone who maybe is more reputable and can kind of help you, actually through the process and solve the problem rather than, what you're dealing with now.
Okay.
Yeah.
Okay. I'll definitely.
Thank John,
you.
Thank
you very much for your time.
Yep. Thank you, Ron. Take care.
I'm still here.
Yep. Have a good one. John, just reviewing Ron's situation there. So he started the Chapter 7 bankruptcy process, but it was never filed. And then a judge told his lawyer that it can't be filed. Is that kind of summing that up? Because he has too much, he doesn't qualify, he doesn't pass the means test for Chapter 7?
Or it may, my understanding, it may not even have been filed because the attorney looked at it and said, "Hey, there's too much equity. That your home is
Right.
worth way too much more than what you owe on it." And in a Chapter 7 case, it's great at getting rid of debt, but they do look to see if you have any assets that can be sold with the money going to your creditors. And certain things, there's all these exemption laws that'll protect your stuff. But in some states, the exemption for the homestead exemption is actually surprisingly low, which I think may be the case here. Boy, I'm looking at Missouri. I think they have a very low homestead, and that may have been the issue.
And that means that you don't need much equity to be disqualified from Chapter 7.
Sure. And granted, I'm doing a quick internet search. They're saying the homestead exemption in Missouri's about $15,000, which is insanely low.
That's hardly a down payment.
Yeah, Arizona, it's $425,000 of equities protected, and then like Florida and Texas, it's unlimited. So sometimes in a Chapter 7, an attorney may have saw that and said, "Hey, you're going to lose your house if we file this 7." The failure was not communicating that to the client, well before this whole mess started happening with lawsuits and that kind of thing.
So when you file bankruptcy, there's a stay that's sent to the creditors or the collectors.
Yeah.
Does it sound like a stay was sent for some reason? It seemed to me like maybe a stay was sent, but then it was removed, which is why I was getting contacted again.
Or
is the stay only sent once the bankruptcy is officially filed?
Correct. You actually have to file the case with the court, you have a case number, a judge, a trustee, everything's assigned. It sounds like what his attorney may do is have them send out these letters that say, "Hey, we're filing for bankruptcy." And it's just kind of like if someone hires an attorney in a debt collection scenario, if they send that letter out, there's a Fair Debt Collection Practices Act that requires the debt collector to go through the attorney. And so they may see a lull in the collection activity for a while.
I say that might have happened, right? The attorney sent out notice to collectors, diverting attention from Ron.
Yeah.
Right. But you're saying it can take a few months for the official stay to go out.
It depends. Yeah. I mean, if you filed the case,
once you get filed, it goes out, but it can take a little while. It can take months to get the filing fully completed.
Yeah. It can take a while to get the case ready to file. Once it files, it's almost immediate. Well, the stay is immediate, and then they send an electronic notice to the creditors, and they receive it within 24 hours.
I see. Right. Folks, that's wrapping up. Thank you for coming on to the debt hotline. We always are accepting live calls at 801-613-8181. We are done for tonight, but you can call in next time. If you are in debt, which I imagine most of the people watching live right now are, you can go to solicit.com to get that debt resolved. You can reply to a lawsuit. You can click the settle a debt button. Right? And we recommend for everybody that if you are being sued for a debt that you owe, right, try to pay back that debt. You can oftentimes settle it at some kind of a discount, which is great. You can come on here, you can chat with our AI and get tips on how do I negotiate a debt? What do I do if I'm sued? Et cetera, et cetera. And you can chat with your legal data as well as your financial data and get the best insights into your position. And you can also click the link in the chat that will support John and get your situation fully wrapped up. John, thanks so much for coming on.
Yeah, thanks, George. I appreciate it. Enjoyed it.